Welcome to Theme 2 Rights and Responsibilities of the AQA GCSE Citizenship course. Today you're going to be looking at universal human rights, particularly what are the key international agreements and treaties that protect our human rights. In the previous video to this session, you were looking at the key words to remember. We're now going to move on to look at the history of human rights. Even though this video is approximately 18 minutes long, it is important that you watch it. It gives you an outline of all the different agreements, treaties, declarations, conventions that have implemented human rights across the world over time. It also gives you some case studies and thoroughly critiques each agreement, looking at pros and cons of that agreement. You need to have this knowledge in order to move on to the next videos. And just to note, the original video was almost 49 minutes and I managed to edit it down to 18 minutes. I hope it's useful. A lot of my students tell me that they get confused with the different international bodies that have been involved in human rights, and they also get slightly confused with all the different human rights conventions and agreements and declarations and documents and so on. So I'm going to run through these with you on this board here. You might want to create a table similar to this too and put the information in as we go through it. In the top left here it says agreement and laws. So this refers to any agreements or laws or declarations or conventions that have been put in place to implement human rights. Next, you've got when, then who, as in which international body or which organisation introduced this agreement or legislation. The next one is who does this apply to? So which countries does this agreement apply to? Why was it introduced and what did it achieve? Finally, outcomes of this agreement and any problems that exist. So the first founding document of human rights is the Universal Declaration of Human Rights. This was introduced in 1948 by the United Nations, the UN. It applied to all countries who are members of the UN. At the moment there are 193 members. Back in 1948 there were not 193 members, there was much less. You go through details regarding the UN in another video, so I won't go into too much depth about that. So technically you can see that the Universal Declaration of Human Rights actually applies to pretty much everyone on the entire planet. Why was it introduced? So it was introduced after World War II. World War II took place between 1939 and 1945, and during that time horrific atrocities took place, namely the Holocaust. The international community, and when I say international community, or your exam paper says international community, it means all the countries around the world, or many of the countries around the world, got together and said that something like the Holocaust should never ever happen again. And that was the birth of the Universal Declaration of Human Rights. This was the first time in history that human rights was formally recognised. So as you can see here, what did it achieve? Recognition of human rights on a formal level, and it provided an understanding of what constitutes human rights. This meant that more countries around the world had a wider understanding of what human rights actually is. So prior to this stage, human rights was not actually a concept that was addressed by many governments and countries. So 1948 was a very significant year for human rights. It's a Universal Declaration of Human Rights, where 30 articles were introduced outlining 30 different human rights and freedoms. However, there was a problem with this document. This document was not actually backed up with any laws or legislation. So it was literally 30 articles identifying rights and entitlements for human beings. Basic, fundamental rights and entitlements. This was a major problem because no one would be held to account if they violated or abused those articles in the Universal Declaration of Human Rights. We would say that the Universal Declaration of Human Rights was not legally binding. So no one was held to account, no one was prosecuted if they abused or violated those human rights identified in this document here. Now we're going to move on to a document that applies specifically to Europe. And this document is called the European Convention of Human Rights. It was introduced in 1953, and what it did was put the articles that existed in the Universal Declaration of Human Rights into a European context and made it applicable to European countries. It was introduced by the Council of Europe. Please make sure you do not get the Council of Europe and the European Council mixed up. They're two totally different things. I won't go into too much detail about this because in another video I do look at different international organisations where we compare the Council of Europe and the European Council. But what you need to know is the Council of Europe introduced the European Convention of Human Rights, not the European Council. It applied to the 47 countries who were members of the Council of Europe. And as mentioned in the name, these were European countries, the UK being one of them. And as with the United Nations, the UK is also a member of the United Nations too, as well as being a member of the Council of Europe. Why was it introduced? It was introduced because they wanted to make human rights legally binding. They wanted to make sure that human rights was being upheld in all those 47 European countries. So to make human rights legally binding across Europe and put human rights into a European context. So making sure that it applies to European countries. What did it achieve? Well, it achieved quite a lot. Firstly, it introduced the European Court of Human Rights. So if one of these 47 countries in the Council of Europe violated or abused any of the human rights contained in the European Convention of Human Rights, which was adopted from the Universal Declaration of Human Rights, they would go to this court, the European Court of Human Rights. There they'll be trialled and prosecuted for their violations. So this was a big step in ensuring that human rights violations were legally binding and people were held to account if they were violating those human rights. The next thing it did is make sure that all of these 47 countries who are members of the Council of Europe ensure that human rights are considered when they're debating and discussing national laws and legislation for their own country. So applying human rights to national laws. So for example, if the UK Parliament was debating and discussing a law in the Houses of Parliament, they would have to make sure that that piece of legislation that they're debating upholds the human rights that were identified in the European Convention of Human Rights. The outcomes of the European Convention of Human Rights was that countries and governments were being held to account for abuses of human rights. Two case studies are the Smith case and the SV Marper case. The Smith case involves a woman who was a lesbian who joined the RAF. She was asked really personal questions about her sexuality and then sacked due to her sexuality. This is a violation of human rights because it violates her freedom from discrimination. SV Marper involved a case where UK government were taken to the European Court of Human Rights because out of all the 47 countries in the Council of Europe, the UK was the only country that would hold onto DNA profiles and fingerprints of those who were charged of a crime, even if they were found not guilty in court. This was an invasion of the human right privacy, because your DNA and your fingerprints should be your own private property, unless in circumstances where you might have committed a crime. But obviously in this case, this person was found not guilty and therefore believed that the fingerprints and DNA should be cleared off the system. This also went to the European Court of Human Rights, where they did find that it was an invasion of privacy. So in both these cases, the European Court of Human Rights was in favour of the individuals and upheld human rights. However, there was a huge problem with the European Convention of Human Rights. There was one court, the European Court of Human Rights, and there was 47 different countries who were members of the Council of Europe. This meant that there was a backlog of cases and it was very expensive to be trialled because there was only one court for 47 different countries. So we can write that here. So the UK decided to create their own piece of legislation that upheld human rights. This piece of legislation would only affect the UK and it was called the Human Rights Act. It was introduced in 1998 but actually came into force in the year 2000. It was introduced by the British government and would have obviously been debated and discussed in Parliament too. And it only applied to the UK. Remember, anything that has Act at the end of it suggests that it's a piece of legislation, a piece of statute law. Statute law is written law. These are laws that are debated and discussed in Parliament and is written down. This means that these pieces of legislation only apply to the UK because they've been debated and discussed by UK Parliament and agreed by them. Why was it introduced? It was introduced because there was one court for 47 different countries and the UK felt that they had to find a solution to this issue. Needed to provide easier access to justice in courts for human rights violations in the UK. There's two main things to remember when you're thinking about what the Human Rights Act achieved. First thing it achieved is all human rights issues and cases that existed in the UK could now be trialled in national courts. And what I mean by that is that it can be trialled in all sorts of courts in the UK. So county courts, magistrates courts, crown courts, and family courts. I won't go into too much detail about the court system in the UK because this information is provided in another video. Another thing you need to know about this point is that even though these cases can be brought to national courts, an individual can continue to appeal up the appeal system, all the way up until the Supreme Court. The Supreme Court can then make a decision, and with many cases, the decision that is made at Supreme Court level stays that way. However, with human rights issues, there is one court that is above the Supreme Court. Supreme Court is the highest court in the UK, but the one court that is above the Supreme Court when it comes to human rights issues is the European Court
of Human Rights, which now became a court that people would go to if they weren't satisfied with the decision made at Supreme Court level. Another achievement of the Human Rights Act is that all public bodies had to promote and uphold human rights. It's really important that you recognise that it's not just upholding human rights, but actually promoting it. Maybe promoting equality and diversity to avoid people's freedom from discrimination from being violated. What I mean by public bodies are any public services, such as the police force, education, healthcare, social services, etc. So what were the outcomes and the problems with this? What you need to remember is the Human Rights Act is not a completely separate agreement to the European Convention of Human Rights. What the Human Rights Act does is that it contextualises the European Convention of Human Rights into the UK in terms of our practices and our legislation. This means that the European Court of Human Rights still applies to the UK. It just means that individuals in the UK can continue to work up the court system and appeal cases beyond the Supreme Court level. So having human rights as a piece of legislation in the UK led to lots of positive outcomes to ensure that human rights violations were prosecuted and trialled in court and people were held to account. However, some of the problems that exist are that some people believe that having the Human Rights Act, which is bound by the European Convention of Human Rights, means that decisions made by UK courts, particularly by the highest court in the UK, the Supreme Court, are undermined by the European Court of Human Rights if someone chooses to take their case beyond the Supreme Court. So this is a problem of the Human Rights Act. It undermines national decisions made in the Supreme Court. The two case studies that examine the problems with the Human Rights Act are the Hurst case and the Abu Khattala case. Hurst involved a prisoner who took the UK government to court because he believed that prisoners should have the right to vote. The right to participate in a democracy is a human right. In the UK, prisoners are not allowed to vote. He felt that this was unfair and a violation of human rights, and the UK government was breaching the Human Rights Act and ultimately violating the convention. He took this to national courts and it worked its way up to the Supreme Court, and the Supreme Court were not in favour of Hurst. In fact, David Cameron, a previous Prime Minister, said that he feels physically sick by the idea of prisoners being given the right to vote. So what he did next is he then took his case to the European Court of Human Rights. When he took it to the European Court of Human Rights, they did say that the UK government is abusing human rights, namely the right to participate in a democracy. However, the European Court of Human Rights did understand the UK government's arguments, and the ultimate ruling was, although it is a violation of human rights, they suggested and recommended that the 47 countries that make up the Council of Europe review their policies and that prisoners should be allowed to vote, but it's up to the government how they allow prisoners to vote. So, for example, allowing prisoners who have a shorter sentence that is shorter than 4 years the ability to vote, but not allowing those who have committed serious crimes or who have been given a harsher, longer sentence. Many countries in the Council of Europe have employed that policy and are now carrying it out because of this case. The UK government still has not, even though it should be, because the UK government is bound by the convention and the convention is legally binding. Abu Khattala is the second case. Abu Khattala came to the UK from Jordan. He was a radical Islamist and was inciting extremism and promoting hate speech. This is a crime in the UK. When the case went to court, it was ruled that he should be sent back to Jordan where he will be trialled. However, his defence team stated that that would be a violation of his human rights. Firstly, he had a family here in the UK, and he said that this would be a violation of his human right because he would be restricted from seeing his family, and ultimately that would be a violation of the right to family life. He also said, and this is the important bit, that if he did go to Jordan to be trialled there, he would be tortured for evidence. This means that his human rights would be violated, freedom from torture would not be upheld, and right to fair trial would not be upheld. Again, this went through the court systems up to the Supreme Court, and the Supreme Court disagreed with him and agreed that he should still be deported back to Jordan. Any individual in his position or in Hurst's position has the right to then appeal further to the European Court of Human Rights if it's a human rights case. So that's what he did. And the European Court of Human Rights overturned that decision made by the Supreme Court and said that he should not be sent back to Jordan unless the UK government is certain that torture will not be used to gain evidence. Remember, freedom from torture is an absolute human right. This should never be taken away from anyone, under any circumstances. And the European Court of Human Rights felt that the UK should find ways to ensure that Abu Khattala will not be tortured. These two cases made some people in the UK feel really angry because they felt that the decisions that were made in the UK by the Supreme Court were being undermined by the European Court of Human Rights. This has led to a call to scrap the Human Rights Act and replace it with something else, and that's what we're going to move on to next. The next piece of legislation we're going to look at is the British Bill of Rights. So the British Bill of Rights does not exist. Please remember that. It does not exist. Different MPs and the Conservative government have discussed and thought about, but it has not been discussed in Parliament or debated, and therefore doesn't exist. But it's something that some people do want to introduce. So this box can have a line in it. Who? So if it was debated and discussed and introduced, it would be the British government and Parliament that would be doing that. Who would it apply to? Again, it would only apply to the UK. And the reason why it would exist is precisely the problems that exist with the Human Rights Act. People feeling that the decisions made in UK courts are undermined. People have also argued that they feel they need a British Bill of Rights that upholds British needs and values. What we mean by British needs and values is that the 47 countries that make up the Council of Europe are 47 separate countries with different values, with different needs, with different traditions. And some people feel that a British Bill of Rights will ensure that the opinions, values and needs of the British people will be upheld. What did it achieve? Well, we can't write anything for that because it doesn't exist. But the outcomes and problems we can write a bit about. Despite the fact that there have been calls to scrap the Human Rights Act and replace it with the British Bill of Rights, there have also been people who absolutely oppose that decision and want to keep the Human Rights Act. They feel that the Human Rights Act has allowed many individuals the right to achieve justice when regarding human rights issues. They also feel that if the British Bill of Rights is introduced and government and parliament can interpret human rights, that human rights will no longer be universal. I'm going to explain that in more detail, but as you can see up in the corner here, it's called the Universal Declaration of Human Rights. And there's a reason why it was called the Universal Declaration of Human Rights. It's because it applied to every single country, and every single country had to be aware that those 30 articles applied to them. People who do not agree with the British Bill of Rights believe that if we allow the British to interpret their own version of human rights, it would dilute human rights. And what I mean by dilute human rights is that human rights would not be black and white. It would be open to interpretation, and it may not serve the purpose that it had initially intended. So, for example, this could lead to situations involving injustice and human rights violations because it leaves what human rights are open to interpretation, and different people and different countries will interpret human rights in a different way, which can lead to dangerous situations, particularly if we have different cultural and traditional beliefs, with some cultural and traditional practices may be deemed a human rights abuse, but if legislation states it isn't, therefore they'll be able to get away with those abuses. Another problem is that if the British decide to create their own British Bill of Rights, other countries from the 47 that make up the Council of Europe might also decide to do the same, and it may have a domino knock-on effect, again undermining the concept of universality. So let's write that down here. So this is the basic sort of information that you need to know about human rights. I just want to reiterate that the European Convention of Human Rights has nothing to do with the European Union. Please do not get those two confused, because a lot of students make the mistake of doing so. For example, in the EU there are 28 members. However, in the Council of Europe, who introduced the European Convention of Human Rights, there are 47 members. They are two different bodies. The EU and the Council of Europe serve two different roles and are two different bodies. The 28 countries that make up the EU also belong to the Council of Europe. The EU also has a European court called the European Court of Justice, which is also, like the European Court of Human Rights, above the Supreme Court, and where EU issues can be taken. But again, the European Court of Justice and the European Court of Human Rights are two totally different courts and deal with two totally different issues. The European Court of Justice deals with EU issues, the European Court of Human Rights deals with human rights issues. So please do not get the two confused. If you have any other questions or you want me to clarify anything, please do make sure you write me a message on the comments box. Thank you very much. I hope this has been helpful.
In this video, we have looked at the history of human rights. In the next video, you'll be looking at case studies involving Hearst, Abu Khattala, and whole life sentences.